Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the limitation period of passing the penalties, and that period is given in section 275. The main purpose of discussing this case is that it has been seen that while passing the penalty orders, generally the revenue misses the bus of the timeline which is given under section 275. So, a proper understanding and a clear understanding of section 275 is very essential. In the present case, the issue before the Honorable Patna High Court was that what is the limitation period for passing the penalty order in case the CIT appeal confirms the additions made by the assessing officer. This issue has been taken up by Honorable Patna High Court in the case of Mahesh Agarwal versus Deputy Commissioner of Income Tax, and this case is reported in 483 ITR, page number 57. The date of the judgment is 20th July 2023. Section 275 talks about bar of limitation for imposing penalty. In the present case, the assessment year involved was 95-96 and 96-97. The additions were made by the assessing officer which were confirmed by the learned CIT appeal, and when this addition was confirmed by CIT appeal, that CIT appeal order was received by the CIT in the financial year 2006-07. But the penalty order was passed on 31st March 2009. When this penalty matter was under consideration, it was the viewpoint of the assessee that as per proviso to section 275 subsection 1 clause A, the limitation period for passing the penalty order was 31st March 2008, but the assessing officer didn't consider the contentions of the assessee and passed the penalty order. So, when this matter was before the High Court, the court analyzed section 275 subsection 1 clause A, which talks that the limitation for passing the penalty orders is twofold. The first period is end of the financial year in which the assessment order is passed. Generally, it is a law that when the additions are made and when the matter is pending before the CIT appeal, the penalties are not imposed till the disposal of the appeal by the CIT appeal. So now comes the second limb of section 275 subsection 1 clause A, which says that whenever there is a matter pending before the CIT appeal or the tribunal and these adjudicating authorities passes their order which is received by the CIT appeal, then the penalty order is to be passed within 6 months from the end of the month in which the order of CIT appeal or tribunal is received by the CIT. But in section 275 subsection 1 clause A, one proviso was inserted, and that proviso provided the extended time to the revenue to pass the penalty orders in cases where the appeal has been decided by the CIT appeal. Proviso to section 275 subsection 1 clause A gives the time limit to the assessing officer to pass the penalty order within 1 year from the end of the month in which the CIT appeal order is received by the PCIT. Friends, there is distinction between section 275 subsection 1 clause A and proviso to section 275 subsection 1 clause A. Section 275 subsection 1 clause A applies to the limitation period when the order is passed by CIT appeal and tribunal, and that too before 1st June 2003. But proviso to section 275 subsection 1 clause A applies for the CIT appeal orders which are passed after on 1st June 2003 or thereafter. So in the present case, by applying the proviso to section 275 subsection 1 clause A, since the order of the CIT appeal was received in the financial year 6-7, so the limitation period was ending on 31st March 2008, and hence the penalty order should have been passed up to 31st March 2008 and hence the penalty order passed in the present case on 31st March 2009 was time barred. At the end of this video, once again I am repeating the name of the case. The name of the case is Mahesh Kumar Agarwal versus Deputy Commissioner of Income Tax, and this case is reported in 483 ITR at page number 57, and the date of the judgment is 20th July 2023. Thank you, friends.